Is the sound okay?
Yes, sound is fine.
Okay. To Allah subhanahu wa ta'ala. It was merely placed in our trust, and now we are absorbed at that trust. We're no longer holding that trust. We no longer have life. We don't have the personality or capacity from a worldly perspective, and therefore that trust falls away. We no longer are holding it in trust. Now it then returns to its true owner, who is Allah subhanahu wa ta'ala. So looking from that dimension, all that we own in our life goes back to Allah subhanahu wa ta'ala. Then the next step is that Allah subhanahu wa ta'ala, in His design, in His wisdom, has set out a pattern, a style, a system, where that same wealth now passes on to the next generation for them to serve as a trust in their hands, by which they will be tested from generation to generation. So when we recognize that it was never ours, it was always belonging to Allah subhanahu wa ta'ala, and upon our demise, our duty or test regarding that wealth has now come to an end. Now Allah subhanahu wa ta'ala has designed who it should go to, in what proportions it should go to. Then from that perspective, when we have this picture and frame of mind before us, it is easy to understand that in terms of the Sharia, there is no freedom of testation. In other words, there's no option from our side regarding this wealth. It belongs to Allah. It was always Allah Ta'ala's, and it goes back to Allah subhanahu wa ta'ala, and He distributes it, not us. Allah subhanahu wa ta'ala distributes it to whom He wishes from the next generation. So from that perspective, we can say that in terms of Sharia, there is no freedom of testation. What is testation? The very concept we were discussing now of drawing up a will, of stipulating who should receive, etc. So in Sharia, there is no absolute freedom of testation. Now, if you look at it from the worldly perspective, the kuffar, their frame of mind, they understand that wealth belongs to a man. When he dies, he should be able to dictate what should be done with his wealth, because it's his, and because of autonomy, that his free will, his choice, which everybody must respect. He has complete, absolute freedom of testation. If he wants, he can do with his wealth what he wishes. Nobody should be able to question him, to the extent that if he decides tomorrow that he wants to give all his wealth to his dog or to his cat, that's his choice. We must live with that. So that concept is not compatible. It is completely opposite to the Islamic picture and outlook. So therefore, from Islamic perspective, when we realize it belongs to Allah subhanahu wa ta'ala, He has set up a system in the Quran Majid where it stipulates who receives, in what proportion they receive, etc. And we merely submit to that. We don't question that, we just merely facilitate that, but we totally, as mu'min, submit to that divine plan which Allah subhanahu wa ta'ala has in place. The next important aspect to keep in mind regarding the aspect of an estate is that this passing of ownership and the rights of the next generation in the proportion set out by Allah subhanahu wa ta'ala is immediate and automatic. It's not a question of choice. It's not a question of whether the dying person had any desire for it or not, or whether the recipient, the heir who is entitled to receive, whether he had any choice or decision-making involved whatsoever. Rather, from the side of Allah Ta'ala, it is automatic, it is stipulated. It occurs what we codify to as ex lege, by operation of the law, by the operation of Allah subhanahu wa ta'ala's law. It's not a contract where it's done by consent, rather, it's automatic by the law of Allah subhanahu wa ta'ala. And to demonstrate that, we'll just mention maybe two quick incidents to give us an idea and a picture of how this occurs by way automatically at the time of demise, and how it has its effect immediately. The first anecdote which is mentioned is that on one occasion, a pious person was called upon to attend to a very sick elderly person. The person was on his deathbed, so he requested that this pious person come to his bedside, recite some Quran for him, and perhaps at the time of death it will be easy, make it easier for him, etc. So this pious person attended to the sick person. He sat at his bedside, and this is an old story. So it's what applied here is that at the bedside there was an oil lamp burning. So after some time, the person who was sick passed away. Immediately upon passing away, this pious person who came to his bedside went over to the lamp and blew the lamp off. So it was dark, it was pitch dark. People asked him, why did you do that? He says, the reason I did that was that for as long as I was sitting here and benefiting from the light of this lamp, it was due to be me being a guest of this person. So as his guest, he allowed me to benefit from this lamp. But the moment he passed away, it is no longer his lamp. The oil that is there in the lamp is no longer his. And I don't have permission of the heirs to use that oil and to benefit from the light of this lamp. Therefore, immediately I blew that lamp off so that I may not be using somebody else's property without their consent. So from there we understand, just an anecdote, but it gives us a reflection of how this transference of rights to the heirs is automatic, it's immediate upon demise. The second incident which comes to mind was the incident of Hazrat Mufti Muhammad Shafi, rahmatullahi alayhi, who is the esteemed father of Mufti Taqi Usmani, Damat Barakatuhum, a famous alim of our time in Pakistan. Mufti Taqi Sahab explains this incident. He says that when my father was quite towards the end of his life, when he was not well, he made this arrangement. He says that what I will do, I have one room or one side of the house where sometimes some guests come to visit me and I'm not well, so they come to visit. I will be stationed in this room. And to make things easy for the arrangements of the house, I've now made the intention that whatever books and my personal belongings in this room, those remain my property. But as far as the rest of the contents of the house, I've given it over to your mother. It belongs to her. So that was the arrangement made. Then Mufti Taqi Sahab explains that occasionally what would used to happen is that my father, he was not well, we used to attend to him. So sometimes we would go to the kitchen, make some tea, bring it in a teacup and saucer, and he would drink from it. But what he would do is that he would, as soon as he was done with those utensils, he would instruct Mufti Taqi Sahab to please return those utensils to the kitchen. So sometimes Mufti Taqi Sahab would delay. He would be busy discussing something with his father. He'd say, I'll do it now. So his father would insist. So, and when he would delay a little longer, then his father would make sure that he immediately takes the cup and saucer back. So then he asked his father, what is the reason? Well, there's no need to haste. I will be going in a few minutes' time down to the kitchen. I'll take it then. Or is there any particular reason why you are insisting that it is be done sooner than later? So then Mufti Shafi Sahab rahmatullahi alayhi explained. He says, since I made the intention that whatever utensils or whatever belongings are in the house all belong to your mother, if perhaps in a few minutes death should come to me, what will happen is that in the process of my death, people will forget about these small items. And that cup and saucer will now remain in this room. And because it remains in the room, people may get the impression that it's actually my property. And because they get the impression it's my property, they will put it into my estate and distribute it as part of my property. Whereas in reality, this cup and saucer does not belong to me, it belongs to your mother. So I have no right to see that it be, I should ensure that she is not deprived of this property of hers, this item of hers. Therefore, I insisted upon you that you must return that cup and saucer immediately. So this also shows the consciousness of these pious people. They are always conscious of death, the immediate nature of death, that death can come to us at any moment, and they were always conscious. They always had this conscience that we should in no way be a source of any person being deprived of their full rights. So from this aspect of it, the passing of ownership and the heirs receiving their rights, it being automatic and immediate upon death, is very important to understand the system of Islamic succession. Then furthermore, to that we said that there's no automatic, or sorry, there's no freedom of testation. There's no absolute freedom of testation in the Sharia. However, there is a small caveat involved that there is a limited degree of testation which is allowed, and this limited degree is called Wasiyyah. We will discuss a little bit about Wasiyyah a little later on. So just keep in mind, as a basic principle, there is no freedom of testation. But as a small aspect, the Sharia does allow some degree of testation, and that is called Wasiyyah. So we call that a limited freedom of testation, or limited degree of testation. Inshallah, we will discuss a little bit about that and further on. Now that we have realized that by the law of Allah Ta'ala has stipulated who the heirs should be and what proportions they will inherit, it's not possible in these few minutes to go through and to explain what those particular formulas are, but just to understand that the Quran has set out specific formulas that has been supplemented by the ahadith, and there is a science involved in which how to calculate who a person's heirs would be, and it's very interlinked. That is, the rights of one category is interlinked with the existence of another category. If we want to ask ourselves, what will the son receive? Then we have to ask ourselves many other questions. How many sons are there? Are there daughters as well? Does the receiver have parents? Etc., etc. And in the light of those other questions, we will have to determine the share entitled by that particular category. So it's not possible for us to go into that, but we should just realize that these have been fixed and set out by Allah Ta'ala in the Quran Majid. So it's our duty to see that this comes to fruition, that this is upheld. And in this regard, we should keep in mind the command that we should obey the limits and the laws of Allah subhanahu wa ta'ala. In this regard, we just go through a few ayat of the Quran related to that. First, in the ayat, Tilka hududullah. These are the limits of Allah subhanahu wa ta'ala. These are the laws and the rules of Allah subhanahu wa ta'ala. وَمَن يُطِعِ اللَّهَ وَرَسُولَهُ يُدْخِلْهُ جَنَّاتٍ تَجْرِي مِن تَحْتِهَا الْأَنْهَارُ خَالِدِينَ فِيهَا وَذَلِكَ الْفَوْزُ الْعَظِيمُ. Whoever obeys Allah and His Rasul sallallahu alaihi wasallam, Allah Ta'ala will cause him to enter into such gardens below which rivers flow, wherein he will remain forever. وَذَلِكَ الْفَوْزُ الْعَظِيمُ. And this is the great success. وَمَن يَعْصِ اللَّهَ وَرَسُولَهُ. And whoever disobeys Allah and His Rasul sallallahu alaihi wasallam, وَيَتَعَدَّ حُدُودَهُ. And he goes beyond the limits of Allah subhanahu wa ta'ala. He disobeys Allah subhanahu wa ta'ala. يُدْخِلْهُ نَارًا خَالِدًا فِيهَا. Allah Ta'ala will cause him to enter into such fire in which he will remain forever. وَلَهُ عَذَابٌ مُهِينٌ. And he will face a disgraceful punishment. Another ayah says, وَمَا كَانَ لِمُؤْمِنٍ وَلَا مُؤْمِنَةٍ إِذَا قَضَى اللَّهُ وَرَسُولُهُ أَمْرًا أَن يَكُونَ لَهُمُ الْخِيَرَةُ مِنْ أَمْرِهِمْ. It is not befitting any male or female believer that when Allah Ta'ala and His Rasul sallallahu alaihi wasallam have decided a matter, that they should have any choice in that matter. When Allah Ta'ala has decided the fixed shares of who should receive and what proportion they should receive, we as mu'min don't have a right to have any choice in those issues. وَمَن يَعْصِ اللَّهَ وَرَسُولَهُ. And whoever disobeys Allah and His Rasul sallallahu alaihi wasallam, فَقَدْ ضَلَّ ضَلَالًا مُبِينًا. Then he is on clear misguidance. And then in the ayat of the Quran in Surah Nisa, where Allah Ta'ala in detail sets out the various shares, etc., those who are fars will know these ayat, yusikum Allah, etc. It's a little bit of a tongue twister for those who are fars, because the wording is a little close. It's a little bit confusing for the fars, so they have this particularly sticks out in their mind. In those ayat, Allah Ta'ala, after discussing those various categories, and then Allah Ta'ala says, آباؤكم وأبناؤكم لا تدرون أيهم أقرب لكم نفعا. Your fathers and your sons, you don't know which are closer to you in benefit, meaning who will benefit you the most, who are most deserving of being benefited, and who will benefit you the most. You don't know. Allah Ta'ala in His knowledge knows that. Allah Ta'ala in His knowledge has fixed who will receive from the wealth you leave behind. Faridatam min Allah, fixed shares from the side of Allah subhanahu wa ta'ala. Whatever Allah Ta'ala has decided, those are stipulated from the side of Allah subhanahu wa ta'ala. Inna Allah kana aliman hakima. Allah Ta'ala is all-knowing, all-wise. Furthermore, another ayat says that if we don't ensure that the rightful heirs receive their share in full, if we deprive them, then this is a great form of injustice whereby a person who is involved, who is a party to such injustice, will receive severe punishment in the sight of Allah subhanahu wa ta'ala. Particularly those categories of people who are vulnerable, who don't have a voice, who cannot stand up for their rights. Those in charge have a duty to see that they do justice and give everyone their rightful shares and be fair to all. In this respect, Allah subhanahu wa ta'ala says, إِنَّ الَّذِينَ يَأْكُلُونَ أَمْوَالَ الْيَتَامَى ظُلْمًا إِنَّمَا يَأْكُلُونَ فِي بُطُونِهِمْ نَارًا وَسَيَصْلَوْنَ سَعِيرًا. Those who consume the wealth of the orphans unjustly, they are consuming in their bellies the fire, that is the fire of Jahannam, and they will soon join up in the scorching punishment. So this is a great warning for depriving those who are entitled to receive from their respective shares. In a hadith, Rasulullah sallallahu alayhi wa sallam one occasion asked the Sahaba radiallahu anhum, do you know who is a pauper, who is a poor person? So Rasulullah sallallahu alayhi wa sallam poses this question to the Sahaba radiallahu anhum. Sahaba radiallahu anhum says, a pauper amongst us is that person who doesn't have wealth, he doesn't have goods, etc. Rasulullah then commented that in my ummah, the true pauper is that person who on the day of Qiyamah will come with a lot of salat, will got a lot of fasting, that is nafil sawm, nafil fasting, zakat, it is extra zakat, etc. But he has abused somebody, he's eaten somebody's wealth, he has violated the rights of another, etc. As a result of which he will have to give over these good deeds over to those whom he had treated unfairly, unjustly. So one is to do good deeds, one is to preserve those good deeds, and one is to be accepted with those good deeds before Allah subhanahu wa ta'ala. And one important component is that we should see that those who are entitled to receive are never deprived of their full rights. So once we've understood this, now we have understood that it's our duty to ensure that those who are entitled to receive in terms of the Quran, they should receive their full rights. Now to unpack our question, the fundamental question that we posed with is that why do we need a will? In order to address that question, we will turn the question on its head and ask another question. What happens if we don't have a will? If a person dies without a will, what happens? So we are living in a non-Muslim state, we are living under the laws of the country, and we are bound by these laws. These laws govern us whether we like it or not. Now, within the system of South African law, if a person does not have a will, it is said that he passes intestate. The term we use is intestate. What is intestate? When a person passes away intestate, when he passes away without a valid will. This could be either in the form that he did have a will, but for some reason that will is not valid, or alternatively, he did not have a will at all. So you pass away intestate. When a person passes away intestate, then it is governed by the Intestate Succession Act, which is Act 81 of 1987. In terms of this act, a particular formula is set out, that who receives in what proportions, etc. Those formulas are set out in the act. And if a person doesn't have a valid will, then in that case, his assets or the residue of his estate will be distributed in terms of the formulas set out in this act. And invariably, in the vast majority of cases, the formula set out in the Quran would be at variance with the formula set out in the Act. In other words, If we go the Islamic route, who is supposed to receive, what proportions they are supposed to receive will be completely different from if we had to go the route of the Intestate Succession Act. So the result would be that if a person doesn't have a valid Islamic will, it will be dealt with in terms of intestate succession, as a result of which the Shari'i heirs, the rightful Shari'i heirs, will be deprived invariably of their rights. There are a few extreme cases where the two formulas could possibly overlap, but in the majority of cases, they will be taking you in down a different lane, a different pathway, producing different results. So in order to avoid that a person's estate be dealt with under the Intestate Succession Act, it is required that a person has a valid Islamic will, in which he will stipulate that when I pass away, I want my estate to be distributed in terms of the Islamic law of succession, the law set out in the Quran, Hadith, etc. In that way, he would ensure that his heirs will receive what they are entitled to. Now, we'll just go over to what aspect we discussed this now, that as far as a person having a right to decide a limited degree of choice, a limited degree of testation. There the Sharia is provided in the form of Wasiyyah. Regarding Wasiyyah, this is limited to 1/3 of the residue of one's estate. So when we say residue, initially as far as the procedure is concerned, from a person's estate, firstly his burial expense will be seen to, then his debts, etc., and then all his assets will be accumulated. And from after his debts have been seen to, from the balance there, 1/3 of that balance may be given over in Wasiyyah. Now, regarding Wasiyyah, a few important rules are firstly, that a person cannot make Wasiyyah for his heirs. It's only for non-heirs. So, for example, his own son, his wife, etc., will fall under the natural heirs or the heirs stipulated in the Quran. So he cannot top it up, he cannot give them further, he cannot stipulate that from this 1/3 they should receive something. Rather, this 1/3 may only be directed in the direction of non-heirs. Secondly, this is an ideal opportunity where a person can use this avenue to benefit himself in the Akhirat as well, where if he stipulates some good works, some charitable works, so he can stipulate, for example, from this 1/3, a portion must go to some charitable cause, a masjid, madrasa, printing of Qurans, whatever that may be. A person can stipulate this within his will. So on the one hand, he now, at the time when he's meeting with Allah subhanahu wa ta'ala, this is an ideal opportunity to also convert his extra assets or cash on hand, etc., in a form that will benefit him in his grave. Then the important rule regarding this society is that it is to a maximum of 1/3. If a person has stipulated more than 1/3, then up to 1/3 would be allowed automatically, but anything further and above 1/3 would require the consent of all heirs. Otherwise, that extra will not be considered to be part of the Wasiyyah. Another important function of a will is to stipulate who the executors are going to be. The executors, as you mentioned, are the managers of a person's estate. So it's important to choose the right people when drawing up one's will. These are the persons who are going to be in charge of winding up the estate and distributing to those who are entitled to receive. So it's important that firstly, these people should be people who have knowledge, who have integrity, and who are able to manage that kind of situations. So sometimes a person may be very pious, very deeni inclined, etc., but he doesn't have the necessary knowledge. Sometimes a person may have a necessary knowledge, but he doesn't have the stature and integrity or the will to stand up and do the right things, particularly in the face of where there may be some resistance or opposition, etc. It must be a person who can ensure that he will be able to manage this process correctly. So who does a person appoint as an executor? That is entirely left upon the person who's drawing up the will, but we just like to suggest a few guidelines. It shouldn't be a person who is so distant from the family. By distant, we don't mean physical distance. What we mean is that it should be a person who has some relationship with the family, who is able to interact and understand the family, understand the dynamics, get along with the heirs, be able to consult with them, and where if they are doing something wrong, he's able to stand up and tell them this is wrong, etc. So it should be somebody who is able to communicate and understand the family dynamics. Further to that, we also recommend that it should also include somebody who is of an independent mind. So sometimes the executor may be within the family or one of their heirs themselves, etc., but then they don't apply an independent mind. So if you have somebody together with them who is a little bit of a distance away, who is objective, who can apply his independent mind, he doesn't have a personal interest in the estate, etc., he'll be able to bring some balance in the administration of the estate. So how many executors does a person have? It's up to the person. He can stipulate as many as he wishes, etc. But generally, as a general guideline, 3 are more than sufficient. Now, the executors, what they do generally to assist them in the clerical work and the filing of papers and the formal process of winding up estate, they acquire the assistance of an attorney or an accountant, because in terms of our South African law, deceased estates may only be administered by a registered attorney or accountant. So they employ the services of such an attorney or accountant, and the attorney or the accountant will then charge a fee for managing and administering the deceased estate. The fees that they charge is, in terms of our law, a maximum of 3.5% of the net value of the estate, and they are also entitled to charge 6% of any income generated. How this comes about? If, for example, the administration, the executors now realize that we're going to carry, this estate is going to take us 6 months to wind up. We have some cash on hand. Instead of it sitting idle, let us invest that cash for the 6 months, so at least that cash may be generating some income. And at the end of the 6 months, when we need to distribute, we can now cash up that investment. So as far as the profit arrived through that investment, the executors are also entitled to 6% of the income generated. So this is a snapshot of the type of fees that are involved in winding up an estate. Some of the more common errors that take place in estates is that sometimes people exclude a rightful heir. As we mentioned, everyone fixed in the sight of Allah subhanahu wa ta'ala is entitled to receive, and no one should be deprived. Sometimes people feel that I didn't have a good relationship with so-and-so relative, therefore I can exclude them. That is not possible. In terms of the law of Allah subhanahu wa ta'ala, that person is entitled to achieve. So therefore, if a person has a disobedient child, for example, he is not allowed to disinherit such a child. No one has a right to reduce the shares that are fixed from the side of Allah subhanahu wa ta'ala. Also, no one has a right to impose or dictate or rule from the grave, to put stipulations that, yes, my son will receive his share, but he'll only receive it when he's 21, or only receive it when he's 25, or only if the executors give permission will he receive his share. The deceased or the person drawing up the will has no right to put these burdens and stipulations. It is now the right of the son, for example, to receive. So he will receive according to the law of Allah subhanahu wa ta'ala, unrestricted, unfettered. Then furthermore, as far as the entire estate, that has to be distributed in terms of the law, the proportions fixed from the side of Sharia. And that applies to every single asset in the estate, from the smallest office pen to the largest property. Every asset has to be shared in that particular proportion. If amongst the heirs they now decide to barter and to exchange a share in one item for a share in another, that can be done voluntarily. But If there's no agreement, everybody has a right in every single asset in the estate. So the deceased or the one drawing up the will cannot stipulate, well, my son must receive this house, my daughter must receive the business, my other son must receive the car. He cannot stipulate which assets go to which particular heir. Furthermore, the one drawing up the will cannot include others who are not heirs. For example, adopted children, grandchildren, they cannot be included as heirs. But because these categories are non-heirs, they can be included in the Wasiyyah portion, which we have discussed earlier, but they cannot be fixed as stipulated heirs as outside of the category of Wasiyyah. Then furthermore, Wasiyyah, we mentioned, is limited to 1/3, therefore a person cannot do more than 1/3. And a person should furthermore also ensure that he does not deprive any of his creditors their rights. Sometimes people make use of various legal strategies, companies, juristic persons, trusts, etc., and they house their assets in these legal vehicles, as a result of which, in terms of the law, those assets are not considered to be part of his estate, and they are not used to pay up the creditors. So he'll be depriving, at times he may be depriving his creditors of their right for dues by employing these various legal ruses and stratagems. So in terms of Sharia, he may get away as far as the law of the land is concerned. But before Allah subhanahu wa ta'ala, he will have to answer why he deprived them of their rights. So therefore, a person should be mindful of not depriving any rightful person of what is due to them. Furthermore, it's important within the household, especially for everyone to have a list, particularly of what belongs to whom. Sometimes there's a lot of confusion, or people just take things for granted that in the household items, whose is it? Is it the wives? Is it the husbands? These the furniture in the house, the loose items, etc. As far as every particular asset, the person should have set down a guideline or a list that which particular assets belongs to him, which particular assets belong to his wife. If they have given anything over to the children, that should be recorded so everybody understands properly what actually belonged to the deceased, as a result of which what forms part of his estate. Now, to resolve this aspect of ensuring that everyone receives their rightful shares, there are the process is fairly easy. A person draws up an Islamic will. Now, where will a person get an Islamic will? The ulama bodies like the Jamiyas, etc., many other bodies offer free Islamic wills, and for the average man, I would say the vast majority, that is more than sufficient. It's a standard form. A person fills in his details, he signs, and generally with the form they have instructions how to sign, who will serve as a witness, etc. Your person follows those instructions, and inshallah, that more or less covers the aspect of him having an Islamic will. Yes, for certain special cases where a person has unique circumstances, perhaps he can consult with an expert who understands both the Sharia and the South African law, and he could design a tailor-made will for his particular circumstances. For the vast majority of people, the standard wills that are available in the marketplace that are more than sufficient. Then is another aspect, is that if a person, perhaps if he passed away without an Islamic will, how do we address such a situation? There we leave it up to the consciousness and the Allah-fearing nature of the heirs, that they should now come together and come to realize that irrespective of what our deceased father, for example, may have done, we need to do the right thing. If he made a mistake, let us overlook that mistake. Let us get together and see that the estate is redistributed in terms of Sharia so that everybody receives what they are rightfully entitled to. So that if a person is faced with such a situation, that then there's still hope of redressing the matter, where parties can come together, all the interested parties come together and see that they do the right thing and redistribute in terms of the Sharia. And this can be accommodated whether the will was Islamic or un-Islamic. Nevertheless, the parties, the heirs, can come together and do a redistribution, and that redistribution is recognized in terms of the law, so they will not be violating the will if they voluntarily enter into such a redistribution agreement. Then the final question we ask ourselves is that, is it a duty to have an Islamic will? So to reply to this question, we use a legal maxim in the Sharia which says that by which if you have a primary obligation, and in order to fulfill that primary obligation, one has to do a secondary act, then that secondary act itself becomes obligatory. And the Arabic maxim we use for that is مَا لَا يَتِمُ الْوَاجِبُ إِلَّا بِهِ فَهُوَ وَاجِبٌ. So here, our primary duty is to ensure that the rightful heirs are not deprived of their heirs fixed by Allah subhanahu wa ta'ala. And because we live within the South African system, the only way we can facilitate for that is by having an Islamic will. Therefore, we come to the conclusion that it is a wajib duty, it is an obligatory duty for every Muslim who has wealth to draw up an Islamic will, and therefore ensure that his estate is dealt with correctly according to the law of Allah subhanahu wa ta'ala. I've put up on the screen my email address and my contact number. Anybody who wishes to contact me, any questions in this regard, feel free to send through your questions. And as far as this session is concerned, what I will do now, inshallah, we can open it up, and anybody wants to pose any questions, you're most welcome to do so.
We have a few questions that have come out. If you allow me to read it out, and then Mr. can address it.
Please go ahead.
The first question that is posed is, if an Islamic will is not made, will the state be forced to distribute the estate according to the Intestate Act? Or if the heirs, then, I would assume that he's intending the Islamic heirs get together, would they be able to intervene in that particular process?
Okay. We mentioned this point that the South African law of succession also recognizes redistribution agreements. That is, where the heirs get together and they voluntarily enter into a contract where they depart from what the will stipulates, but they do so voluntarily. In those circumstances, they can facilitate the redistribution in terms of Sharia, as long as they're all adults, they give their free consent, that is easy to manage. So it's in those circumstances, it will be their duty to do so. There may be certain complications where there are minors, etc. Or, for example, if in terms of the will, by way of example, only 3 heirs were included and 2 were excluded. And now in terms of the redistribution, we're putting all 5 together. There may be certain tax implications, etc., but it is legally possible to address such situations.
Okay, so the important point to take out from there is that we will require the cooperation of those people who would be entitled in terms of the incorrect will or in terms of the intestate succession.
That's correct.
The next question that we have, how is maintenance of a child when it comes to divorced parents, how is maintenance of a child dealt with in an Islamic will, bearing in mind that there are other heirs or children from a second marriage?
I think there's 2 aspects here. One, we brought up the aspect of divorce. So now consider that when we're dealing with a deceased estate, the aspect of divorce doesn't play a role here. In other words, let's take an example. The father passes away, but prior to him passing away, he had already divorced his wife. So she is no longer his wife. In that respect, she doesn't inherit in his estate because she's no longer his wife. But as far as his children, they are still his children and they will still inherit from his estate. Whether he was estranged from his wife, whether he was divorced from his wife, whether he had a relationship with his children, etc., those are immaterial. The fact that there is a biological link, and they are his children, they're entitled to receive the respective shares. If they are minor, and whilst the estate is being wound up. If they require subsistence to see to their basic needs, in the meanwhile, it will be the duty of the executor to see to their maintenance in the interim before they receive their full shares.
The next question, what happens to the estate of a person who is the only Muslim in his family and he dies having left behind an Islamic will? And the question is specifically related to the fact that his non-Muslim relatives may have an interest and fight for the estate.
So there's two aspects here. One is that if he draws up an Islamic will, then we'll deal with that angle. And once he's got an Islamic will, we will look for if he has any relative, even be a distant relative who is a Muslim, that distant relative will, no matter how far down the line he may be related, that distant Muslim relative will be entitled to his estate. As far as him bequeathing, in terms of Sharia, he can use the 1/3 for his non-Muslim relatives. He can stipulate that from this 1/3, so-and-so relative must inherit. For that 1/3 wasiyyah to be applicable, the recipient doesn't have to be a Muslim. The requirement of a Muslim, it relates to the 2/3 or the main portion of his will, where the Quran has fixed shares. So as far as the fixed shares of the Quran, a non-Muslim cannot inherit from a Muslim. But as far as wasiyyat is concerned, from that category, the non-Muslim can benefit. And in this case of an ideal situation where we're living in an Islamic state, if he had no heirs, then the residue would go to the Baytul Mal, the public treasury. However, in our circumstances, we don't have a public treasury, etc. So in those circumstances, the ulama advise that the residue of his estate be given in some charitable avenue.
Jazakumullah khairan. And also a point just to add on that is that many of the standard world forms and templates that are available have a clause wherein the testator can stipulate a specific organization where his residue can go to in the event of no heirs succeeding him. The next question we have here, Mufti Saab. Will Mufti Saab please discuss the permissibility to take out a life policy to cover the estate duty?
This is an issue that has come up recently for debate amongst the Muftis, etc. The question arises that in terms of our South African law, up to 3.5 million, a person's estate is, so to say, tax-free. But when it goes beyond 3.5 million, the tax rate is 25%. So if one has a substantial estate, take for example 10 million, then roughly 6.5 million will be taxable at a rate of 25%. So a significant portion will go in the form of taxes. So can a person then accommodate for that by taking out insurance to cover the estate duty? So the Muftiyan have discussed this issue and says, as long as there's provision that this particular mechanism is not abused in any way, this will be something permissible, but it's important to keep in mind specific to these circumstances. The person should not misunderstand that insurance in itself is something permissible. Rather, to avoid one injustice, this form of insurance is permitted to save or to protect the rights of the heirs. Otherwise, they would be deprived to a large degree. So the concern is that should there be any residue from the insurance payout, it should be in no way benefit the heirs whatsoever. If there is any residue, it should be given over in charity. But the primary purpose of this entire mechanism is to ensure that through the proceeds of the insurance or the payout of the insurance, that would cover the estate duty. So on the one hand, by means of this mechanism, one is enhancing or protecting the rights of the heirs, and therefore, in this limited kinds of scenarios, the Muftiyan have allowed it.
The next question is it appropriate and correct for a sibling to encourage the other to give the deceased mother's property to the father? And okay, that's the first question that this person posed.
Okay. As far as any form of redistribution, it is imperative that there be no pressure whatsoever. One has to respect the rights of every individual. If for whatever reason any individual heir does not want to part with any portion of their rights, etc., it is absolutely wrong and haram to put pressure on them, to have expectations that they must forego their rights. They are fully entitled to their rights, and everybody should respect the fact that they do not want to relinquish those rights. And that is where it's important to have the right type of executors who come in and who create the balance and to see that fairness and justice is done.
How does the husband, I think the question is posed in this manner, what is the most efficient manner in which the husband can give perhaps 50% of his residential property to his wife in a manner that is Sharia compliant and legally efficient during his lifetime?
As far as this is concerned, there is, he could in his lifetime give 50% undivided shares to his wife. In terms of Sharia, the ideal way would be to do it in a form of a sale and not in the form of a donation. The reason for that is that in terms of Sharia, for a donation to be valid, it requires a separation of the joint asset and also possession by the donee, that is the recipient of the recipient's share. So because hiba can be sometimes, or donation can be sometimes problematic, we advise parties to undertake a sale, even if that sale be at a nominal value. So a person on paper could tell his wife that I'm sending you 50% of the matrimonial home and for 100 Rand. If they put that document down and the husband and wife sign it, in terms of the Sharia, that is considered a valid transaction, and the wife now owns 50% undivided share in that property. And then at the time of the demise of the husband, only his 50% will then be distributed amongst his heirs.
Jazakumullah khairan. The next question, can a trustee be appointed in the will for a minor heir?
The term trustee is quite something quite distinct, where we have a formal trust. So a person could, in his will, stipulate that because they are minors, I want the share of the minors to be put into a trust. So but in the will, he's actually incorporating two contracts. The one is the instruction regarding his estate. The other is the formulation of a trust we call as trust mortis causa, that is a trust set up after a person's demise. So he could, to facilitate the protection of the minor's wealth, he could also stipulate that the share that should be going to the minor should be held in trust. These are the trustees, this is how they would deal with the trust, etc. He can give instructions regarding that. But it is also important to keep in mind that in terms of the Sharia, once the minor reaches that age where he is able to manage his own affairs, from that point on, the minor is entitled to receive those funds, and the trustees cannot impose their will over the minor. The minor, it's his property, he is the dominus, he owns it, he can dictate as far as that property is concerned, and the trustees cannot override it.
What do we do if the heirs don't want to distribute the estate according to Sharia?
Again, we can appeal to their consciences, we can remind them of their duty to Allah subhanahu wa ta'ala, remind them of the fact that they too have to pass away, they have to meet Allah subhanahu wa ta'ala, and just as they would like that nobody do injustice to their heirs, similarly they should see that they do not do injustice to others. The best we can appeal to their conscience and make dua for them. From a formal point of view, from a legal point of view, if they want to persist in that which conforms to South African law but does not conform to the Sharia, we cannot enforce it. We can only appeal to them.
The next question, how often should we be updating our will?
That will depend much on a person's financial situations and circumstances, etc. Like I said, for the vast majority of people, the standard will see to their needs, and therefore there's no need to, so to say, update the word, because the instructions are going to remain the same. At best, they will maybe change in the executors, etc. But where a person has unique circumstances and his financial position changes from time to time, etc., he may, as a ballpoint figure, depending on the degree of change in his position, but as a ballpoint guidance, every 3 years, a person should open up his will and see, do I need to change anything? He can consult with his legal advisor, etc. That will be just a rough guide.
Okay. What structure should be put in place before death of a business owner to ensure continuity of the business?
There's quite a bit of detail regarding this, but essentially, in the case of a joint business, then it's important that at the time or immediately upon death of one of the partners, that a temporary arrangement is made with the remaining partners and the heirs of the deceased to allow for some type of interim period of adjustment so that everything could be wound up in a systematic, orderly fashion. By way of example, there are two brothers in a business and one passes away. If we are not going to make a on-the-turn interim arrangement, it would mean that immediately upon the demise, that business must cease to exist, must immediately stop trading, and immediately split up all the fine assets, which from a practical perspective is extremely difficult. So what we encourage in those situations that immediately upon the death, and we mean immediately, soon after that, the surviving partner and the heirs of the deceased get together and says, can we just arrange for a 3-month moratorium, a 3-month interim period? You give us permission, we'll continue the business, we'll give you a proper accounting, we'll do a stock taking, etc. But it's not practical for us to close doors immediately. So within those 3 months, they, with some oversight, they can do a stock take, they can value the business, they can make proper arrangements and negotiate who is going to take over, etc. So that will be the ideal way of dealing with such situations from a practical perspective.
Okay. There's a follow-up question to one that came earlier relating to whether a property is partially sold to the spouse. The question is, will the sale of an undivided share in the property, will it need to be legally registered? The second part to it is, wouldn't it be deemed a donation if sold at nominal value?
There are two aspects of this. One is for the purposes of Sharia, we record and undertake a sale transaction, and we recognize that for our internal purposes, that 50% does belong to the wife. But in those circumstances, my suggestion to clients who have similar situations is that for the purpose of legal purposes, they should delay the transfer. Don't include it immediately. The reason is that when you transfer as part of a winding up of an estate, then the transference from one spouse to the other is duty-free, tax-free, etc. So formally, from a legal perspective, we'll delay the transfer upon death. But internally, within the family, there should be a clear record and understanding that for the purposes of Sharia, this asset doesn't belong, in the example we use, doesn't belong to the father, it belongs actually to father and mother. So in that way, we can cover both angles.
Just to follow up on that, so in that case, would the testator record in his will that, for the purposes of distribution, that 50% of the house should go to the wife in exclusivity of the other heirs?
What we normally do is have an internal document where the close heirs or the most probable heirs and the deceased, the husband and wife, formally record this, and everybody signs on so that there's no opportunity of dispute down the line, and that way it covers that angle.
And what about the donation if sold at nominal value?
Like I said, that is for internal purposes. So although
Okay,
it's
all right.
formal,
So it's not.
it's not put up as part of a formal legal document.
Yeah. Jazakumullah. When household items are distributed, do we distribute it on the basis of do each of them need to be valued independently, or can there be a sort of random distribution?
If by mutual agreement they want to do a random distribution, by all means, the heirs are adults and they can mutually agree. However, if they cannot reach any agreement and they want to go strictly by the letter of the law, then they will have to distribute like for like. For example, you've got a dining set with 12 pieces, and there are 10 heirs and 6 heirs, and each heir will take 2 pieces. In that way, they'll distribute asset for asset. And those which cannot be distributed like for like, they'll have to determine a market value. Somebody can purchase it at that market value, and assuming nobody wants to purchase it, as an absolute last resort, they sell those assets in the open market and they distribute the cash received.
So, there's a question here relating to investments and money in a bank account, where a specific beneficiary was stipulated in the will as a recipient, to receive that particular investment. I assume that perhaps that principle is general, that where a specific A is mentioned to receive a particular asset, then from a Sharia perspective, to what extent can it be upheld?
Okay. We briefly touched on this point, is that in terms of Sharia, the person, the testator, the one drawing up the will or signing the will, has no right to stipulate which particular class of asset or which particular identified asset must go to which particular heir. Rather, each and every asset in his estate belongs to all his heirs, and then they may mutually agree to redistribute.
Where should we keep our will so that it's easily available upon demise?
Okay, this is also very important. We would suggest at least make 2 or 3 copies. Keep it with responsible people within the family who will have access to it. Perhaps one in a safe place, for example, in a vault or with some other relative away, distance away, so that Allah forbid, if there's some disaster or some, for example, fire in the house, etc., you have at least one copy at an external place. People generally just that in a form where it's easily accessible after your demise and people are aware of it. It shouldn't be that only one private person within the family is aware of it and he has the opportunity, Allah forbid, to conceal it, etc. A few copies, in the absence of the original, a copy would be sufficient for legal purposes.
The last question, can an heir dispose of property for her benefit if the other heir disposed of most of the estate?
I didn't really understand the question, but the principle is that none of the heirs are allowed to disperse or distribute or sell off any of the assets without the consent of the others. Whatever has to be done with unanimous consent. So if there was violation of this rule, I think that creates a situation which is being referred to in the question.
So that brings us to the end of the questions that we've received. We would like to express our deepest gratitude to yourself, for availing yourself for this particular program. And indeed, from the questions that have arisen, we noticed that it's been extremely engaging and beneficial. May Allah subhanahu wa ta'ala reward you. And inshallah, we look forward to having you address us on similar topics and other topics which are Sharia legal related, whereby we can benefit through your knowledge, inshallah. And we also would like to thank the attendees for presenting yourself. We would like to remind you of the other webinars and programs that we've got planned during this lockdown period. During the course of next week on Monday and Friday, which are both public holidays, at 2:30, we've got 2 webinars on important topics. One being giving back to the community as a professional or a businessman, business person. And the second being the need for halal certification. a very pertinent topic as well, which applies to us living as Muslims here in South Africa. So we encourage you to participate, register for those seminars, webinars as well, and encourage your friends and family as well to register and benefit. We have a unique opportunity during this time, and we've got an easy access to our great scholars and the leaders in our community from whom we can benefit tremendously. So we request you to please join, register, and benefit from them. Jazakumullahu khairan.
Once again, Jazakallah to you, Marana, for this opportunity, and may Allah Ta'ala make it beneficial. Wa akhiru da'wana alhamdulillahi rabbil alameen.
Assalamu alaikum wa rahmatullahi wa barakatuh.
Wa alaikum assalam wa rahmatullahi wa barakatuh.